Megan Fox.
Yeah, Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox writes at PJ Media.
Eat Tucker.
And that was your last.
Damn it, man. I cried for 2 days.
Megan, thank you very much for that.
So, I can explain the bed thing.
If you don't show up and vote, up your ass. I don't care if you're in the hospital. Crawl to the stake. Crawl there.
It's like Jesus going into the temple. He's like, I got a whip! Get out! Get out! The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood in his toe thumb.
Megan Fox.
Megan. And honestly, Megan, if you don't like it, I'm sorry.
She's the devil.
Megan.
Megan Fox.
Megan.
Megan.
Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go? Holy sh!
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's.
You pissed off the wrong woman.
Oh my God! I have been assaulted when Megan Fox runs wild on you, brother.
She's the devil.
Not for publication.
The story.
I'm Megan.
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 Megan Fox.
Mr.
Thank
Atkins,
you.
cheers.
Cheers.
Hey guys, how are you? Happy afternoon or evening or morning, wherever you are, because a lot of you come from a lot of places. So it's fun to have you here with me. I'm Megan Fox. If you are just tuning into this channel, if you're new here, I am a journalist. I work for pjmedia.com, and I have a new article up just today about Court TV and the cranks over there that did what they did to Maya yesterday that pissed me off so badly. And I do want you to go and clickety click on that, because those of you who can't send a Rumble rant or a super chat or a Cash App or a Venmo to support the show, you can use your thumbs, use those opposable thumbs to hit clickety click on my article, which I am dropping right now in the chat for you. This is a new one about what they did at Court TV to Maya Kowalski yesterday. And I really didn't like it. I didn't like it at all. No, didn't like it at all. In fact, I don't think the chat liked it either, because they made this for me. And I really, really appreciate that, Locals chat. My Locals chat, by the way, is the place to be. meganfox.locals.com. There is a live chat going on over there right now where they make hilarious memes about the Court TV twat waffles who decided that it was a bigger story that Maya Kowalski wore a short red dress to homecoming than it was that JHACH got its ass handed to them in court by Judge Carroll and has to turn over all the damning documents about their IJ report. Yeah, it's a problem. That's what we're going to go over today, by the way. So court is not in session today. We are going to read motions. And thank you to, I think Allison sent these to me. I love it that you guys send stuff like this to me. We're going to read the jury motion first, the motion to disqualify a juror. That's what we're going to go to first. Yeah, I know Fox News did it too, and so did the New York Post, because here's what happens. Court, wait a minute. Is Legal Vices live right now? Oh, is he still doing Steve's stream? I was on that earlier today. Is he still doing the Ghazni stream? Is that still going? Steve was almost at the at his goal when I left, like hours ago. And by the way, Steve Ghazni has a new children's book, and Legal Vices was streaming about that, and probably is still right now. And you should all go to steveghazni.com and buy a copy of his book about that little doggy. What was the doggy's name? Not Buster. It's not Buster. What is his name? No, I'm forgetting it. Well, just go to steveghazni.com and buy the new children's book. All right. Oh, they must be really drunk by now because they were really sauced when I was there this morning. Brucey! That's the name of the dog. Yes, go over there. All right. Thank you to the chat, though, for sending me this motion. So we're going to look at the jury motion. We know that the defense, we call it the Dick defense here. The Dick defense has filed a motion to disqualify a juror, and we're going to find out why. We don't know why yet, but we're going to find out. Here we go. And I think it's because they believe that this juror is biased against them. But here's the thing I don't understand. Let me just put this out here. And for those of you who are new here, if my computer freezes and I disappear for a few minutes, just hang tight. The chat will keep you entertained until I come back. I have bad computer problems. The thing about this that I don't understand is that at some point during a trial, the jury is going to become biased against one side or the other. That is the nature of court. It's the nature of the game. The game is convince the jury to take your side over your opponent's. That is the game. Halfway through or at the end of the game, I don't think that it's fair to say, hey, the plaintiff is doing a better job convincing this jury that we're a bag of dicks, and so we want them kicked off. But that was their job. The plaintiff's job was to convince the jury that you guys are a bunch of twat waffles and bitch burritos. I got that from Mo in the Deep yesterday, the bitch burrito. That's their job. And so if they do their job really well, and unfortunately for you, Dick defense, the jury is like, you're a bunch of dicks. And you're kind of understanding that from their questioning. Well, that's kind of like too bad for you. I mean, all right, let's get to it. But I think that that's like that's my initial take before even reading this. I think, all right, let's embiggen it so we can all read it. All right, here we go. Defendant Johns Hopkins All Children's Hospital, Incorporated by and through undersigned counsel, moves this court for an order disqualifying juror number 1 from... Should I do it in Shapiro's ASMR voice? From serving on the jury, which deliberates to decide the above styled cause. Defendants submits that juror number 1 on multiple occasions and through multiple questions and statements communicated to the court in connection with questions has revealed a bias and prejudice in favor of plaintiffs and against the defendant. Your Honor, their bias is detrimental to our case. A violation of this court's instructions to the jury not to form or express any opinion about the case until retiring to the jury room to consider a verdict after having heard all of the evidence, the closing arguments of the attorneys, and the charge of the court. All right, I can't keep that up. I don't think I can keep that up. No, I'm sorry. I forgot the cunt cannolis. You're right. I did. If the jury decides you're a cunt cannoli halfway through trial, I feel like that's your fault. You know? All right. Maybe you guys like the Shapiro face or voice. So maybe I should keep doing it. The sulky face. Right. He was like, All right, let's go back. In support hereof, your movement states as follows. Throughout the trial of this cause, the jury duly sworn to hear this case, along with the alternates selected, appear to have paid diligent attention, and their attention has been reflected in a substantial number of juror questions. In the process of posing such questions, however, one juror, identified as juror number 1 in his questions, has repeatedly revealed not only a substantial bias and prejudice in favor of plaintiffs and against defendant, but also a violation of this court's instructions as set forth in the Florida Standard Jury Instruction 1.1 that he or she should not form or express any opinion about this case until you have retired to the jury room. I already said this earlier in the other paragraph, and I'm just repeating myself now. Juror number 1 statements evidencing the above include, but are not limited to, the following. A. Most recently in questioning Nurse Sylvia Ballweg. Which one was she? Which saint was she? Oh! Wait, was she the one who I did not go over her testimony? Thank you, Jermaine, for the super chat. It says, Your Honor, our case is detrimental to our case, but we're going to low-key blame juror number 1 in his questions. Yes. 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 I'm sorry, I'm trying to catch up on your chats. Needs more whining, but impressive. Oh, the nicer nurse. Which one was she? Oh, the old one. You know what? That's the one with the gray hair, the short gray hair. Ballwig? Her name was Ballwig? Really? Is that like the companion piece to the Baldo? Is there a ball wig for the follically impaired balls? I don't know. I'm just asking. Oh my god, I almost did a spit take. Remember Miss Ballburger? Sir, I have a family vacation. Sir, you can't make us do more depositions. I have a family vacation. I know that our witness lied. I know that we let him get away with that, but sir, I have a family vacation. I don't know if I'm gonna be able to get through this. All right, Pale Rogue sent me the photo on locals. Okay, let me hop over to the locals chat because I need to know who this is. I need to know who what's her name? Ballbreaker? What? Ballwig? Ball something. Why is nothing showing up for me? Where are the chats? I'm gonna have to refresh my screen. Oh no. Stay tuned. This could get ugly. Please, computer, pray to the computer gods that it survives the refresh. Ah, there she is. Ballwig. All right, so we need to identify her. Here she is. This is what she looks like. You know, I didn't actually listen to her. I mean, I listened to it on high speed, and I didn't really find anything in it that I thought was worthwhile. I don't know. I wasn't interested. Let's just put it that way. I wasn't interested in it. Okay. Let's get back to Shapiro doing ASMR. This is how he talks to Maya on the stand. All right. In case you're wondering, what is this weird voice that I'm doing? I'm doing Attorney Shapiro's voice that he does when he talks to Maya on the stand. Most recently, in questioning Nurse Sylvia Ballweg, a witness called by defendant, the juror prefaced a question by making a statement to the effect that the witness was a breath of fresh air, or words to that effect, since she was the first person from defendant who appeared to have cared about Maya Kowalski. Oh my God, Shapiro. Oh my God. How on earth did you put this many people on the stand that the jury absolutely fucking hated? How did you do that? That this woman, this one woman, was the only one where they were like, oh, here's the first person who appears to have cared for this kid. Because it's true. They put up witness after witness that were the witches of the 7th floor coven with their dyed black hair and their borderline personality disorders or their histrionic personality disorders, with their flirting and winking at the jury and their and she was swearing at us. It was so bad. It was so bad. I'm sorry, more vocal fry. She was swearing. She was swearing all over the floor. She was just swearing everywhere. The swears were going up and down the ceilings, and the swears and the cursive words, they were everywhere. The swears were just ejecting out of her like Linda Blair in The Exorcist, and they were just coming out of her mouth, and they were just swearing. She was swearing. The swearing was everywhere. That's who they kept putting up on the stand. All these witches who kept saying this, it was either, and then the other one, and well, she was the loveliest little girl. We just loved her so much when she wasn't swearing like Linda Blair in The Exorcist. Oh, come on. That's their whole case. It's crazy. This is crazy. So it's the jury's fault that you put witnesses up on the stand that they hated, that they could tell were completely insincere, and that they were thinking to themselves, gee, if my kid was in the hospital, I hope none of these bitches come anywhere near them. Because you'd be worried they'd be drawing pentagrams on the floor and sticking you with an IV on accident to, like, cut an artery so they could get a drink. More vocal fry. And the only one that said anything nice doesn't work there anymore. That should tell you something, and it tells the jury something. All right. Don't forget, the F word is so offensive to me that the same day I used the F word in a text. Because the F word is super offensive, and I never use it. Well, except for when I'm talking about my patients and violating HIPAA. Well, then I use it. All right. We're never going to get through this. In a question to defense witness Kelly Thatcher, APRN, Nurse Ratchet, I remember her, juror number 1 asserted that his ethnic background, we know it's a man now, was the same as the decedent Beata Kowalski, with the result that both the juror and the decedent tended to be pushy. Yeah, this is a Polish thing, and any Polish person, any Polish person knows this, especially about Polish women. I actually work with the Polish princess at work. She's the bartender. I love her so much. And we talk all the time, and we've been talking about this case. She just watched the documentary. I told her, I was like, you have to watch it. And she was so mad after she watched it. She goes, that's me. I do that. I'm like that. And I said, I know. We know. She's like, so they can take your kid away just because you're a pushy Polish gal? Yeah, it's crazy. Okay, we'll get back to it. Juror number 1 stated specifically that he had identified with the decedent and questioned whether the witness had overreacted to the decedent, suggesting a belief that she had done so due to the decedent's ethnicity. Well, did they? It's a valid question. It's a validation. It's a valid question. Yeah, they're being biased against the juror. That's right. Oh, Megan, you're a breath of fresh air. Dang, I'm showing my bias. Yeah, God forbid anyone should have an opinion and be biased in any way. I'm biased towards the truth. I have to tell you, I'm very biased towards truth-telling. And none of those 7th floor coven witches told the truth. Not one of them. Lacey says, I smell racism. Yeah, So now they want to remove the juror because he's Polish? What is it with JHACH and their hatred of Polish people? They hated Beata. They took away her kid, drove her to suicide, and now they want to kick off a juror for being Polish. I don't know how this works. I don't think this works. I don't think this is going to work for you, Shapiro. All right, getting back to it. Now we're on letter C. Juror number 1 asked a question of an early witness stating there appears to be probable cause of improper action of Sally Smith in her assigned role at JHACH, thus indicating that the juror had formed and was expressing an opinion regarding the case and the evidence in violation of the court's instruction and indicating a predilection against defendant. Do you think it's weird that he didn't specify what early witness? Well, which one? I want to go back and see what if I want to go back and see the questioning? Is it that outrageous that a juror might think Sally had stepped out of her role? And the juror said it appears to be probable cause of improper action. Appears. The juror is asking, well, show me that it isn't. I don't see anything wrong with that at all. Trophy Wife, thanks for the super chat, says Germans and Polish are pushy. I lived in Germany for 6 years. I can't. Why? I can't tell German jokes. Nope, not going there. My inner Nick Ricada is screaming to get out right now. No, chat. No chat. Bad chat. I just got my monetization back. Guys, I don't know where to get this PDF. It was just it was sent to me in my inbox. Okay. One of you sent it to me, and I very much appreciate that, by the way. Oh, locals. Oh my god, you guys. meganfox.locals.com. The memes. Here's what they needed. Here's what the defense needs. They need to put this on their walls and look at it every morning before they leave for work. Don't be a twat waffle. Don't be a cuntosaurus. Don't be a cunt cake. Don't be a twatopotamus. If they had done any of those things, the jury wouldn't hate them. But the jury does hate them because they are all of those things. It's too bad they didn't learn how not to be twat waffles. I don't know. Did they teach that in law school? How not to piss off a jury? Because I feel like that they have done a very poor job in ingratiating themselves, shall we say, to the jury. They've done a very, very bad job of that. Don't forget Thunder Cunt. That's our favorite. That's one of my favorites. Yep. Court TV talking heads could use those as well. They should have to stick that on their computer screen in the morning before they log on, just to remind themselves, don't be a cuntosaurus today. You hear that, Julie Grant at Court TV? Don't be a cuntosaurus today. Try hard. I know it's difficult for you. Try not to smear child abuse victims today. All right. Here we go. Letter D. Juror number 1 expressed an opinion in preface to questioning of witnesses indicating an understanding CRPS can come and go, get worse or reside / disappear, thus reflecting not only an opinion about certain matters in issue, but an acceptance of plaintiff's evidence before having heard defendants. So are they really arguing that CRPS doesn't come and go? Where is Mo? I need Mo in the deep. I need Mo in the deep back. Where are you, Mo? How? This is so bullshit. Anyone who talks about CRPS, who has it, who tells you their experiences, they all tell you that they have a base pain, right? In fact, Mo just told me this yesterday. She says her base pain rate is 5 out of 10. That's a good day. A 5 is a good day. That's the base pain rate. There are some days that it's aggravated and she'll be at an 8, a 9, or a 10. when you go back, and then you go back to the base rate. You never go to no pain, but you go back to the base rate. This is a fact of CRPS. And he is really trying to claim in this motion that that's not a fact. Well, you didn't wait for us to tell you that we know everything about CRPS, even though we didn't have any experts on it. And we know how people feel inside because we have a magic machine. And one of the nurses testified about it. It's a pain machine, and no one else has heard of it before, but we know how many people are in pain just by looking at them. And if they wear short dresses, they're definitely not in pain. This is their argument. Please remember to hit that like button and subscribe. If it's happening with Harper, if you're late, I am reading the defense's motion to disqualify a juror, but I'm doing it in Shapiro's ASMR voice. Oh, God. Oh, my God. So they're arguing that the expert on the stand, the CRPS expert, both Kirkpatrick and Chopra, don't understand CRPS. That's really what they're going for. That's really what they're going for. And if you've ever posted any photos to social media, you're definitely not in pain. That's how we can tell. And they didn't wait to hear our evidence about how posting on social media immediately removes all of your pain. They did not wait to hear that. They didn't wait to hear that evidence. They just took this doctor's advice. They took his word for it because he's been, studying it for 30 years or whatever. But it doesn't matter. They didn't wait for us to put up our evidence that shows very clearly if you post photos of yourself wearing a short dress or if you have a boyfriend, you're definitely not in pain ever. Yeah, don't get me started, Lacey Ann, because I will start getting pissed. I'm already pissed. I'm pissed at the Court TV cunts for doing what they did, at Julie Grant and Court TV for smearing her, for dragging this child through more trauma. This is exactly why she doesn't go to therapy. The pictures being thrown out there like that, everything is discoverable. How would you like it for the last 5 years of your life to have been discoverable at every turn when you're a teenager? Imagine her ages between, so what she's, how old, what's 17 minus 5? I can't do math in my head. I'm a journalist, not an engineer, okay? I don't have to do math. Whatever 17 minus 5 is, 12? Is it 12? I'm going to guess that it's 12. I'm right. Oh my God. I actually got it right. And it was before anyone said it in the chat. All right. Anyway, can you imagine the ages of 12 to 17 being discoverable in your past? Holy shit, I wouldn't have survived it. Discoverable and put on national television. I'm a journalist, not a blackjack dealer. I can't even play blackjack because I can't do math in my head like that. I lose so fast because I don't know where I am at any time. It's really horrible. It's a real disability being medium smart. I wish I had a math brain. My kids have math brains, or at least 2 of them do. My oldest is more like me. We can't do math in our heads. All right. Oh, bravo, chick. I am so glad to hear this. Ever since I found out all these awesome YouTubers covering this trial, I haven't looked at friggin' Court TV or Law and Crime. Don't miss them one bit, and y'all do so much better of job. Well, you are never going to hear the phrase twat waffle or cuntosaurus on Court TV, and they're poorer for it, if you ask me. They're poorer for it. Especially because they're just full of them. They just don't even know it. All right, let's go back. E. Questioning various witnesses called by the defense, including Charlotte Laporte, in an adversarial manner, confronting her with questions regarding whether she can, beyond doubt, affirm that, or whatever she was able to attest to, matters she addressed in her testimony, specifically those relating to Catherine Beatty and telephone calls, again indicating an adversarial predilection against that testimony and in favor of the plaintiffs. Judge, save us from this horrible jury. They're bullying us. They're bullying us from the stand. Oh, TX Angel, thanks for the super chat. Says, thank you for all you do. I love the way you cover this trial and tell it how it is. There is no other way to tell it. There's only one way to tell it, and that way is to tell it how it is. Unhung Hero says, twat waffles. There are not enough names in the Urban Dictionary for these people, and the level of slime where they ooze. There aren't enough words. Well, okay, see, this is why, Crystal, this is why it's so slimy. They all agreed to the questions that were asked. I don't understand. Yeah, they did. And there were times where these things that he's complaining about, the preambles were taken out of the question and were not read to the jury. Because it's the judge's job and the lawyer's job to make sure that the questions are asked in the appropriate way. And so the idea that wait, hold on a second. What is happening? Hold on. I have to send a text. It's Nick. Hold on. Hold on. All right. I'm telling him to shut up because I'm streaming. I can't pay attention and stream at the same time. They all agreed to the questions. They did. And now it's really slimy. It's really slimy that they are now trying to say, oh, now it's not fair and now we don't like it. And why didn't they do it then? Why didn't they do it then? Like when it came up, at the time that it came up, are you asking for my article on the Court TV or theirs? Don't go and give them clicks. Don't you dare. Just go and click on my article instead and read about what they did. Read about what those ball wags did. Ball wag really does sound like an insult. I don't know what it is. I'm not. What kind of name is that, by the way? Ball wag. I can't get it out of my head. Regardless if a juror is removed, they have to try. Unhung Hero. Yeah, I guess they have to try. I guess. I guess they have to try. But I think that this is a sad attempt. It's a sad attempt. All right, let's move on. Questioning various ways. Okay, I got that one. Letter F. Questioning witnesses, including Ms. Tori Mijas, as to whether her team or the hospital possessed certain photographic or video evidence. By posing this question long before testimony, it has been concluded or argument submitted, the juror has indicated that a burden has been placed upon defendant above and beyond any contemplated by the court. Well, now this one I don't even understand. I mean, they're not allowed to ask what evidence there is. They want to know, do you have any? And if you have some, they're signaling to you that if you have this evidence that they think would be helpful, that you should by all means show it to the jury. I don't understand why that's a problem. That there does not show any bias to me. They're literally just asking for locals. Shapiro is Stuart Smalley. People like me. I'm good enough. I'm smart enough. Gosh darn it. Nobody likes me. Well, stop it, locals. Stop it. You're throwing me off. No, it's not true. I love you. Thank you. Stuart Shapiro. All right, moving on. I have to get back over to my page. I should really move this to the other screen so I don't have to keep. Hold on. Let me try moving this around. Whoops, sorry, I screwed it up. Whoops. There we go. Okay. F, where are we at? G. In questioning Miss Laporte, the juror in question began a question with the representation that plaintiffs had provided a dress for Maya Kowalski to defendant or Miss Beatty, indicating prejudgment of the evidence with respect to that issue, and without having heard all of the evidence pursuant to the court's instruction. So are you saying that her parents did not give her a dress? They never introduced any information that the dress didn't exist. Yeah, this is so stupid. Where is their evidence that there was no dress? They're now saying that there was no dress. Is that it? There was some evidence that the family was totally lying about giving her a Christmas dress because it doesn't exist. There's no dress. Have you seen a dress? Maybe Kathy Beatty sold it, we're not sure, but there was no dress. I mean, this is silly. Yeah, I mean, Jack testified that he gave the dress. So, is the jury just supposed to automatically not believe anything that the Kowalskis have to say? Why would someone lie about giving their daughter a Christmas dress? That doesn't make any sense. It's just so dumb. Okay, letter H. In the same question set, the juror in question confronted Miss Laporte with questions regarding whether she knew that the dress was in question resided in Miss Beatty's office, and or whether the witness knew it was not given timely given to Maya Kowalski, indicating an acceptance of plaintiff's evidence before having heard all of the same, and indicating an opinion with respect thereto, both of which violate the court's instruction. The dress does not exist. If the dress does not exist, the jury must acquit. Oh my God. Yeah, the hospital claims that the white dress was the Christmas dress, and Jack says it was the blue one, and the blue one has never come up again. We've never seen the blue one. It's in the dumpster with Jesus. Yeah, check the dumpster. Check the dumpster, because we know for a fact that there's Jesus and cake in there. Chocolate cake. Jesus and chocolate cake are in the dumpster. I have footage of it. Here we have Ms. Niehaus dumping Jesus in a dumpster and the chocolate cake, because she confiscated that too. They should show this to the jury for evidence. Here's your evidence, jury. Oh God. Was it a blue dress or a gold dress? Who knows? I can't tell. Oh. But Your Honor, the jury is doing their job correctly, and that's not fair. Yeah, there was no pictures of the Tommy Hilfiger dress. I think Kathy Beatty sold it on that Facebook. What is that Facebook shop? Not shop. What do they call it? It's like a Facebook garage sale. I ruined that joke. All right. We have one person in the chat who says that my Shapiro voice is distracting and I should stop it. What do you all think? Should I stop and read in my normal voice? I feel like you're enjoying it. Okay. Yeah, porch pickup. Marketplace. Facebook Marketplace. Now, Megan, you have to give grace to him or her. I mean, her, even though she stole cake from a child and threw Jesus in the dumpster. Oh, yes. Grace for all, even evil child kidnappers. Not here, not on this channel. Sorry. There's no grace here for that. All right. All right. I should use Shapiro ASMR voice for my normal voice. I couldn't do that. All right, let's continue. Mm. All right, I promise that I'll read the other motion in my normal voice, okay? But I'm having too much fun with Shapiro right now. Letter I. Questioning at least one witness with the preface that plaintiff Maya Kowalski was more mature than a usual 10-year-old and or handled her pain differently, thus expressing opinions that reflect acceptance of plaintiff's evidence and testimony and expressing opinions regarding the same again in violation of this court's instruction. Does anybody believe that Maya was just a normal, regular 10-year-old when she was in all the advanced classes and she's got this huge vocabulary and she was obviously very smart? Even some of the nurses said she was more mature than her age. Come on, you got this is silly. I don't think that the judge will take that into deliberation at all on that one. Letter J. Questioning witness Stephanie Graham in an adversarial manner regarding statistics related to the success of her case ratio and also regarding her interrogation of plaintiff Jack Kowalski, despite the witness's own testimony that the discussion in question with Mr. Kowalski was an interview and not an interrogation, thus indicating an adversarial attitude and bias against defendant's witnesses. Oh, this was the cop. Yeah, well, she was terrible. She was terrible. Absolutely terrible. This pisses me off. Like, it was, wait a minute. Despite the witness's own testimony that the discussion in question with Mr. Kowalski was an interview, not an interrogation. Oh, just because she says it was, the jury has to accept that? The jury has to accept that? Just because she says that? That's not how court works. The jury is the fact finder, and they are allowed to look at the witness, listen to what's coming out of the witness's mouth, and decide that it's total bullshit. They have that right. And if they did that, well, too bad. They've all heard the tape, and it sure sounded like an interrogation to me. If you were in that room, I bet you would have thought it was an interrogation. All right, letter K. My voice is getting a little tired, so we'll just get through this because I want to get to the plaintiff's motion. Questioning witness Richard Elliott in a sarcastic and biased manner, indicating an opinion regarding the subject of his testimony, which was billing. Oh, you mean that guy who winked at the jury? Yeah, well, maybe, Shapiro, you shouldn't put a guy on the stand who winks at the jury. Maybe you shouldn't do that. Maybe if you had not done that, they wouldn't have been hostile to him. That dude winked at them. Questioning witness Billy Seisel after a preface referring to him as a newbie, indicating a bias against the credibility of the witness. Well, that's just the way that normal people speak, though. No, the people on the jury are not lawyers. And it's amazing to me that jury questions, which are allowed in the state, don't allow, like, can be used by one party or the other. Elliot's the I thought Elliot was no, it says the subject of his testimony was billing. Are you sure there weren't more Elliots? Remember that guy that, I know there was a Dr. Elliot, but was the other guy an Elliot too? Oh, Banker was the billings guy? His name was actually Banker? That's funny. All right, I don't remember Elliot testifying about billing though. Oh, yes, I do. Okay, Elliot was Dime Store Pee Wee Herman. All right, sorry. So it wasn't that guy that winked. It was Dime Store Pee Wee Herman. And yeah, well, if the jury was questioning him in a sarcastic and biased manner, maybe they just didn't believe him. And Dr. Elliot was the elf on the shelf, right? That's funny. He did kind of look like an elf on the shelf. Yeah, the insurance guy. Who was the insurance guy? Was his name Banker? He was the one that winked. All right, anyway. L, questioning witness Billy Seisel. Oh, we already got that one. M, questioning witness Billy Seisel after prefacing the same with, is it possible that Maya's waning abilities could be contributed to JHACH causing the limiting of family interactions, the stress and trauma Maya has testified to, documented statements by Maya about her mother's status told by hospital staff, Miss Beatty. The juror's statement not only flies in the face of this court's instruction to the jury regarding the role of DCF, but also accepts as true plaintiff's evidence long before having heard all of the evidence, as well as an opinion regarding the evidence, all of which violates this court's instruction. I don't know, it seems whiny to me. Letter N, questioning witness Sally Smith by referencing plaintiff's testimony regarding the length of time that it purportedly took hospital staff to respond to telephone calls, thus indicating an acceptance of such testimony without having heard all of the evidence and also expressing an opinion regarding the same. To respond to the length of time, I don't remember this testimony, so I don't know why the jury, if they're going to be able to do this to the jury, then they shouldn't let the jury ask questions. Because the jury is not trained on how to ask questions so that they do not reflect opinions or biases. They're not trained on that, so they shouldn't be held accountable for it. I don't understand that. You know, and if they do disqualify this juror, imagine being the juror who has been so invested in this case and given up 29 days of his life so far. And they're going to throw him off the jury for this, for being invested in the case, for paying attention, and for getting it right. That's bullshit. The jurors are biased against somebody in a case. That is the whole point of the game. Yeah, they did not instruct the jury on how to ask questions. And so because of that, if there is no instruction to the jury about how to ask a question, then how do you hold them accountable for violating whatever these rules in Shapiro's head about jury questions are? Nonsense. And I do believe Judge Carroll probably will not allow them to. Oh, although he might, because he's been very, very careful about anything for appeal. And this is obviously going to go for, if he denies this motion, they're going to use it in their appeal. Yeah, and so in order to avoid any appellate issues, the judge may have to just release the juror. But I think it's really wrong. Oh, my husband is making zuppa toscana right now, and I can smell it. It smells amazing. I cannot wait. He makes the best zuppa toscana. It's great having an Italian husband. He cooks. He is such a good cook, and his soups are incredible. And this one, it's got sausage and bacon and cream and spinach. Oh, so good. I cannot wait for dinner tonight. All right, let's see. Letter O. During the same sequence of questions to witness Sally Smith, implying that the hospital itself was guilty of child abuse. Well, if the shoe fits. The questions indicate an obvious bias in favor of plaintiffs against defendant, and again suggest a violation of this. Shapiro, it is not the jury's problem. It is not the jury's problem that your case is so bad and all of your witnesses are 7th floor coven witches. It's not their fault. I know we use spinach instead of kale. I know kale is usually what you use, but I like the spinach, so that's what we do. All right. Let's see. Number 3. Oh, I have to make this a little smaller. A party seeking to remove a juror for improper behavior in the course of a trial must show that the juror's actions amount to misconduct. How is this misconduct? Asking questions when we're not instructed how to ask them. A trial court must excuse a juror when there is reasonable doubt whether a juror is impartial. Well, why didn't he raise these issues earlier, though? Why wait till the end and waste this person's time? Reasonable doubt as to a juror's impartiality should be resolved in favor of excusing the juror. That's what I'm worried about. I think that that's usually how they do it. They just excuse the juror to avoid any issues. But I feel bad for this juror because that sucks. Bias need not be demonstrated with unmistakable clarity. While a trial court is afforded great discretion in ruling on challenges of jurors for cause, close cases involving challenges to the impartiality of potential jurors should be resolved in favor of excusing the juror rather than leaving doubt as to impartiality. While the decision to accept or dismiss a putative juror is considered an exercise in discretion, we view the seating of a juror as to whom there is a reasonable doubt concerning impartiality and abuse of discretion and thus manifest error. Well, you did the voir dire. You sat the jury. I don't know. I think it's crappy. Yeah, they'll just use an alternate then. Totally not a Russian bot. Thanks for the super chat. Says, does your husband speak italics or only cursive? He speaks lots of cursive words. Yep, all the cursive words. Cursive words. Duncan Idaho says, Baldos. Thank you. Thank you for that. As set forth herein, the standard for juror misconduct is satisfied in light of juror number one's apparent prejudice and bias revealed throughout the course of the trial through his questions and demeanor. And well, where did he even reference any demeanor? There wasn't any demeanor referenced. So are they going to get to that? Do we get to hear about demeanor now? He didn't say anything about body language or rolling eyes or crossing arms or any of that, or sighing or anything. And even if there were any doubt regarding juror number one's bias in favor of the plaintiffs, and there is not, that doubt must be resolved in favor of disqualification under Florida law. As a practical matter, moreover, obvious bias on part of a juror risks a hung jury if other jurors believe the juror in question has violated his oath. Finally, no party will be prejudiced by removing juror number one, given that an ample number of alternates have been chosen, and the alternates in question appear to have been every bit as attentive as the primary jurors. Such a procedure has been approved by multiple Florida courts. In Allberger, for example, a personal injury jury was permitted to ask questions, as the jury has here. At the close of the evidence, appellee objected to one of the jurors on the grounds that, from the nature and manner of that juror's questions and comments, it was apparent that the juror had shown bias and lack of objectivity, as in this case. The trial court substituted an alternate for the juror in question over appellate's objection and did so without questioning the juror as to whether the third district held that there was no error in the trial court's doing so, or in the manner in which it did so, deferring to the trial court's discretion in finding that the juror was no longer objective and unbiased under Florida Standard Jury Instruction 1.1. In doing so, the third district noted that any purported error was harmless in that the alternate juror had been chosen, qualified, and present throughout the entire proceeding. Although Florida case law is not uniform on whether questioning a juror before disqualification is necessary, Allberger supports the proposition that the act of questioning a juror under the circumstances at issue could reinforce his or her prejudice or bias without cause. In addition, given the extent of juror number one's apparent bias, prejudice, and failure to follow instructions, any questioning by this court would serve no useful purpose, given that the juror is well beyond any rehabilitation and would risk alienating not only the juror in question, but also other jurors. Wherefore, Defendant Johns Hopkins All Children's Hospital, Inc. moves this court to disqualify juror number one for the reasons set forth herein and substituting the first alternate in his place. Yeah, I agree. This is blaming the juror for something the court allows. And to begin with, plus the whole point of a juror is to make a decision. Yeah. I mean, Yeah, they had their chance to find jurors they liked during voir dire. Yes, they did. They did. But I mean, this is something the law allows. And most likely, if you ask me what I think is going to happen, I think the judge is going to dismiss the juror. And I think when that juror gets out of court and hopefully comes across our videos and our coverage, maybe we'll hear from that juror about what that experience was like. I would love to interview that juror. Juror number 1, hit me up, because I think this is not fair, but it probably will. I'm thinking the judge will do it. All right. Moving on to the next motion. Where is the next motion? Hold on. We are now. Oh, by the way, the locals chat. If you guys have got to go see the Indy Anderson Jones memes. The Indy Anderson Jones memes. The locals has made, because we believe that Greg Anderson looks like Indiana Jones. And they made some hilarious, absolutely hilarious Indiana Jones memes. They're calling them Indy Anderson Jones. That's at meganfox.locals.com. The live chat is open and it's fun in there. I'll tell you what, it's fun in there. Don't forget to hit the like button and subscribe if you like the coverage. I will be covering the rest of this trial as much as I possibly can between my work schedule. So I'm trying to pull up the other one. Where is it? Where's the email? I accidentally just closed it. I didn't mean to. Hold on, it's here somewhere. Aha! This is the plaintiff's motion for taking the deposition that the judge said they were entitled to after JHACH put an expert on the stand to lie. To lie. And actually, before I go there, let's go over to my new article, because I have some information that's pertinent to this at pjmedia.com. And we have a new look at our site now. It's much different now than it was. Different colors, different layout. It's kind of fun. So I'm going to skip down to the bottom after I go after the twat waffle at Core TV. All right, I'm going to start here. So they sexualized and defamed a teenager in order to protect their clients from the very bad things they've done. And boy, oh boy, are they bad. If Court TV really wanted a story, it would have told the one that came out in court on Thursday instead of wasting space on some kids trick-or-treating. It turns out that JHACH was under a federal investigation for widespread and egregious failures to address patient safety, communication failures involving risk management, and higher administration that put lives in jeopardy, negligently harming kids in their heart unit, and, unbelievably, having a surgical staff that didn't wash their hands, among other horrors. This was all going on while Maya was incarcerated on the 7th floor of the pediatric intensive care unit. The investigation also found that the hospital had major risks for infectious disease spreading due to poor standards. It came out in the trial that Maya's infusion port went unflushed for a month until her mother, who was accused of medically abusing her, demanded that they clean it. There are definitely medical abusers in this story. None of them have the last name Kowalski. But the real bombshell was that JHACH's attorneys put an expert witness on the stand who said the hospital had done nothing wrong and had passed all the inspections and Joint Commission reports during the time that Maya was getting treatment there. That was a lie. And the plaintiff's lawyers uncovered it. This led to the judge storming out of the room after asking very seriously, "Let me make sure I understand. Did the defense adduce evidence to have your witness bless the hospital and make it appear to the jury that everything was hunky-dory with the Joint Commission?" After listening to the defense stutter and fail to come up with an answer, Judge Carroll abruptly stood up and left the room, announcing that he needed a 5-minute break. He looked like he was going to strangle the quaking attorneys in front of him. Let's refresh our memory.
It was in part during the relevant time period.
Let me make sure I understand. Did the defense adduce evidence to have your witness bless the hospital and make it appear to the jury that everything was hunky-dory with the Joint Commission?
I don't believe so, Your Honor, but I was not in the room when Dr. Anderson testified.
I'm going
If
to take a
I could-
5-minute break.
If I,
5 minutes.
All rise, this court in recess.
Fuck off, defense. Oh boy, when Judge Carroll returned, he let JHACH's attorneys know that due to this incident, he was ordering JHACH to turn over all relevant documents they had withheld from the plaintiff and ordered the hospital to send their corporate representative to be deposed on Friday, today, which is happening behind closed doors, unfortunately. This development is huge. For one, the defense was caught lying to the judge and the jury, and because of it, the entire trial timeline was upended, as Judge Carroll informed them that they could kiss their end dates goodbye. But Judge, I have a family vacation. Further, it looks like the jury is going to get to hear all about the investigations into JHACH from both the Department of Health and Human Services and the Joint Commission. If those reports are shown to the jury, it is proof of everything the plaintiff alleged. It's game over. The smoking gun. This was the real story, but Court TV and the New York Post ran salacious photos of a minor abuse victim trying to live a normal teen life after her childhood and her mother were cruelly stolen from her by the crooks at JHACH. They thought it was a bigger story to smear a minor child who has seen more sadness than any of us could imagine, and not the potential disbarment of JHACH's attorneys and the nuclear bomb that the immediate jeopardy finding from the Joint Commission set off. Let that sink in. Court TV didn't report on the biggest in-court drama we've seen maybe ever. We have gone beyond the point of a negligent press and hurtled right into the realm of a deliberately evil press that will ignore a huge story of corruption, lies, and scandal that led to the deaths and abuse of innocent people in favor of fake news that serves only to hurt the victim of that corruption. Julie Grant and Court TV should be ashamed of themselves. They're not reporters. They're worse than tabloid journalists, because at least the tabloids get some stories right once in a while. They are yellow journalists, scraping the bottom of the barrel and exploiting and abusing a traumatized young woman for clicks. All right, so that was the second part of my article. If you want to read the entire thing, I really would encourage you to click on it. It costs you nothing to click on it and share it on social media. Because social media really, big tech is censoring. They censor us at PJ Media. So I need your help in order to spread that. So please do. Please do. No, the judge did not rule on the juror yet. I think he will probably take it up on Monday. But let's get over now to the next motion we're going to read by the plaintiffs. This is the motion that comes after the judge said we're going to depose the hospital now. So here it comes. Please take notice that on November 3rd, 2023 at 4 p.m. Eastern, the plaintiffs, by and through undersigned counsel, will take the videotaped deposition of defendant's corporate representative before a notary public or other officer duly authorized by law to take said depositions pursuant to Rule 1.310 of the Florida Rules of Civil Procedure. Deposition will be taken at Hill Ward Henderson 101 East Kennedy Boulevard in Tampa, Florida, to be accessible via Zoom video conferencing. The deposition will be recorded via stenographic, how do I say that word? Stenographic means, and video by Carolyn Loudon and Associates. The deponent shall bring the following documents. I love this sentence. The deponent shall bring the following documents and other items to the deposition for inspection and copying or use by deponent for refreshing recollection and testimony, and subject to any agreed or entered protective order as attached to Schedule A. Said deposition is being taken for discovery purposes, use at trial, and such other purposes as are permitted by the applicable and governing rules by law. Designation of corporate representative. Pursuant to Florida rules, Johns Hopkins All Children's Hospital shall designate one or more officers, directors, or managing agents or other persons who consent to do so to testify on its behalf with regard to the following issues, and shall state the manners the matters on which each person designated will testify. The issue and matters on which examination is requested are 1. Any and all interactions with and or surveys conducted by the Joint Commission, CMS, AHCA, or any other similar accreditation or governing entities between 2012 and 2019. Any and all corrective action plans and or similar improvement efforts undertaken by Johns Hopkins All Children's Hospital at any time between 2015 and 2019. Any and all self-reports and or findings, surveys, reports, and or classifications of immediate jeopardy and the reasons therefore. Signed by Gregory Anderson, Esquire, and Nicholas P. Whitney. And Jennifer Anderson, is that his wife? Does he practice with his wife? All right, here's Schedule A. 1. You guys are asking me if I can upload these PDFs somewhere so you can have them. If I knew how to do that, maybe I can put them on Locals. I think I can upload documents to Locals. So I'll try. I'll try to put it on Locals. So go to meganfox.locals.com and I will try to post them there. All right. Esme says, yes, it's his wife. Oh, his wife is a lawyer too. Has she been in court? Have we seen her? Has she been behind him in court? Is she one of the women who sits behind? There's a fruit fly in my office. You'd think it was cold enough that they'd all be dead by now. All right. The smell of that soup is going to end this stream early. I'm telling you what. I want to get down there. All right. Any and all Joint Commission and or CMS surveys, reports, findings, and or audits conducted and or issued anytime between 2012 and 2019. Any and all preliminary findings from either the Joint Commission and or CMS between 2012 and 2019. Any and all preliminary reports, reports from either the Joint Commission and or CMS between those dates. Any and all prior surveys that the Joint Commission and or CMS between 2012 and 2019. Any and all preliminary surveys from either the Joint Commission and or CMS between 2012 and 2019. Any and all self-reports, which is what Hunter claimed they did. Now, I'm not sure that that's true. Any and all self-reports or complaints, whether internal or external, to the Joint Commission or CMS regarding Johns Hopkins All Children's Hospital. Any and all corrective action plans, whether draft, proposed, rejected, and or accepted by the Joint Commission and or CMS between those dates. Any and all findings, reports, surveys indicating a classification of immediate jeopardy from either the Joint Commission or CMS between those dates. AP, I agree with you. Shall is a great word. It's such a nice way to say must. Too bad people just skip past it in certain sentences, especially if said sentences have a negative directly succeeding it. Yeah, shall is a great word. It's a really good word. It's a demand. It is an order. It is not, it's not optional. You shall do this. It's like the way I speak to my children. You shall clean your room. I'm going to start using that. You shall clean your room immediately. I'm going to start writing orders to my children. I'm going to practice my legal skills by writing orders about what they shall and shall not do. Yes, Lois. Please send any self-reports to get ahead of the inspection. We want to see those. Yes, shall not be infringed. It's a good word. It's a good word. Really good word. All right. We're moving on down to page 5. Any and all internal communications, emails. Oh boy. Oh boy. Emails and or memorandums concerning a finding of classification of immediate jeopardy issued by either CMS or the Joint Commission between, oh boy, now we're listing all the people that we want. Daily quick bites. Thou shalt cleaneth thy room at least once per Fortnite. All right. Senior Vice President, Medical Affairs and Chief Quality Officer M. Epstein and or his successor, the President, Chief Officer, Vice Dean, Physician-in-Chief, J. Ellen or K. Sowers, or any other interim CEO or successor thereto. Oh my God, they might find through this, you guys, they might actually find internal emails that show that upper management did know about Maya, and they've all got on the stand and said they didn't. This is going to be bad. I mean, it could be very bad for the hospital. Vice President, Government Affairs, Corporate Relations, A. McGuire, or his successor, J. Ellen, K. Sowers. Who else? Executive Vice President Stenberg, the President, Chief Executive Officer, Vice Dean, J. Ellen or K. Sowers. Any and all reports, surveys, findings, and or loud traffic, and or corrective action plans accessible via the Joint Commission's web portal or other similar interface. Printout of the Johns Hopkins All Children's Hospital web portal and or other similar interface with the Joint Commission showing the documents available to Johns Hopkins All Children's Hospital and the date accessed. Mrs. Mischievous RN says, literally post legal summons and demands for chores and such. Just copy and paste the task and the child into a standard form. That would be so funny. My kids would get a kick out of that. Yeah, loud noises. Loud noises. I don't like loud noises when I'm streaming. But sometimes trucks go by and they are just so loud. At least they weren't motorcycles. All right. Any and all emails, letters, and or other written communications between the Joint Commission and any individual at Johns Hopkins All Children's Hospital holding the title of Vice President or higher within the last 72 hours. Oh, that's a big one. Within the last 72 hours. Holy shit. If the hospital did not know that it was a possibility that the judge would order them to turn over everything, after they found out what happened in court, they could have been furiously typing emails. That's how you catch them. That's how you catch them. That's a good one. This reads a lot like a FOIA request, by the way. When I send Freedom of Information requests out, that's how I do it. When I ask for emails, I ask for that for a specific time frame. And it's usually after they've been notified that I'm onto them. I want the time frame from that moment to this moment. And that's where you usually get all the good stuff. I also will ask people sometimes to send me any emails with my name in it. That's a good way to get them as well. Because then you catch these board members talking about you in the emails. Oh, speaking of board members, hey, let's take a break for a second because I have a fun announcement. I have a great announcement. You guys have been waiting for it for a long time. Do you remember when I sued the Wauwatosa School Board with Robert Barnes? It was last October, and I went to the via Zoom, the Wauwatosa School Board, in order to just report on what was going on. There were a bunch of angry families there to protest against the pornographic materials in their curriculum. Hold on, I have to stop sharing so my camera will stop doing this. Please work. Okay. Anyway, so I went there, and I was really just there to report and watch and bring it to you guys. We watched it together, if you remember. But they broke so many rules and they violated so many people's rights that I decided to speak. And a funny thing happened when I did that. And I want to show you, because there's a lot of new people here who might not know this story, but that lawsuit has come to a close. And it's all bad news for the school district. It's not bad news for me. So we have reached a settlement, and Robert Barnes is going to come on the program on Wednesday during lunch of the Maya trial. Robert Barnes is going to come on the show with me to talk about it and all the winnings, all the stuff they are going to have to do. And it's good. This is why you sue these people. So they cut me off while I was speaking to them. And this is a very short video. I'm just going to watch it for the new people who haven't seen it. This is what happened at the Wauwatosa School Board meeting when I was with Farron, and we were just carrying it on the channel. This is what happened.
Please state your name and address.
All right. Hello, my name is Megan Fox, and I'll tell you why I'm not going to give you my address. For one, I just read your Wisconsin Rules of Open Meetings Act. It's a law. And the law in Wisconsin is that the public has a right to participate in your meetings, and nowhere in it does it say that anyone has to dox themselves online in order to participate in a public meeting. I want you to know that school boards like yourselves have been sued successfully before in the past for doing this. It's considered an intimidation technique. Now, you can sigh and put your face in your hands, but you need to listen to me when I tell you that you can be sued for what you're doing. You are violating people's rights. And what you did today by cutting off public comment in the beginning of the meeting when you had a full house of people who wanted to speak to you, and you made them wait 2 hours, and most of them had to go home because they had to work jobs tomorrow, or because they had to get kids somewhere, or because they had to go home and get dinner. What you did is violating the public's First Amendment rights to address their public bodies for grievances. It is a violation of the Constitution, and you should each be ashamed. Sharon, you should be ashamed of yourself. Leanne, you should be ashamed of yourself. Michael, you should be ashamed of yourself. And you too, Jenny, and you too, Jessica. And let me tell you something else. When people use names in front of your school board and they come in and they say, I want to talk to you about a specific person on the board, you are not allowed to tell them that their First Amendment right to speak is curtailed in some way because they want to use a name. That is illegal. What you are doing is against the Wisconsin Open Meetings Act. Now, listen, I have 3 minutes, and I know that my time is not up. You are not to interrupt me while I am speaking. This is public comment time, and I'm a member of the public. You can sit there and be as uncomfortable as you want, but I have this 3 minutes. So listen to me, Michael. When you are talking to people, when they come here to see you, you are put into this position, by the way, by the people of this town. They are your first priority.
Surprise. Where are you?
They are your first priority. They are the people you're responsible
Do you need me to mute this?
Yes.
Why would you mute me?
Okay. Sorry,
my
I couldn't
3
hear
minutes
you
are
over
not
there.
up. My 3 minutes are not up.
At the point where we start
Wow.
respecting individual board members, we devolved.
Well, they're wrong.
If you've already spoken, your time is up on that topic. Anyone?
My time was not up, by the way. They're
Oh.
full of crap. Longest 3 minutes. Look at them. They're so uncomfortable.
The chair has the right to cut off comment if the comment is not aligned with the dignity of the body.
Oh, no, you don't.
So, just to put that out there.
That is not what the First
if
Amendment
there's
says.
something inappropriate being said,
What was inappropriate?
now, that's a judgment call. That's true.
What?
But the chair does have authority to do that.
Oh,
The chair does not have authority under our rules to cut off a board member. We have no time limits. So I can just keep talking here once you recognize me. But to
Look at how
say
uncomfortable they are.
whether you support me or not in the community, we have an orderly process.
What was unorderly about that? I had
And
3 minutes.
The chair is running the meetings and the chair has certain discretions, and that's
I could sue him
okay.
for this.
That's probably a good idea.
You should.
I should.
Second thing about
All right. And I did. And with your help, I did sue them with Robert Barnes as my attorney. I bothered Barnes for like months, and then he took it last winter. And we've been in negotiations with them since then. And they have issued me a public letter of apology, which I will read on the stream with Robert Barnes on Wednesday. And they have written a check. They've written a couple checks. They've written one to me, and they've written one to my legal team. and they have covered the entirety of the legal costs. And I refused to sign a confidentiality agreement. I refused. I refused to sign any confidentiality agreement so that we could speak about this publicly, because the entire point of suing them was not to get a check. It was to teach the public how to hold these people accountable when they do things like break your rights. And that's what they did. They broke laws and they violated my rights. And so now not everybody can raise $10,000 to sue people like that, but they need to. And that's this Maya case, the case of Maya Kowalski. Again, it is a petition to the government, to the judicial branch. It's a petition for relief, right? That's what a lawsuit is. And sometimes that's the only way that you can get any kind of justice. And so this motion actually reminds me a lot of the way I write FOIAs to discover people like that and the bad things that they're doing. So make sure you tune in on Wednesday around 1 o'clock when the court goes to lunch. Robert Barnes is going to join me on my channel, and we're going to read through the settlement. We're going to read the letter of apology, and we'll have more to say about that and about why it's important to do that, why it's important to sue when people violate your rights. Our court system is useful for that. It really is. All right, here we go. Let's go back to the motion. Yeah, I know you guys in the chat are asking about Farron. I assume, I think she's doing well. She's totally off of YouTube now. She's just working, and she just didn't want to be on YouTube anymore. And I don't blame her. She had a tough time. Bad Weather Biker, thanks for the super chat, says, thank you for introducing us to Mo yesterday. Spent last night binge watching her. She's absolutely hilarious. Oh, she sure is. Mo in the Deep. If you, is it Mo in the Deep End? Yeah. Look her up and subscribe. She's so funny. All right. Do I think it was a form letter of apology? No. It was tailored to me. All right, now we even have a fly running around in here. It's driving me crazy. Not a fruit fly. Now it's a regular fly. They're just bothering me today. All right, so we got the emails in the last 72 hours. They want any emails, letters, or other written communication in the last 72 hours by anyone holding the title vice president or higher. That's interesting. 14, they use the judge's words, anything with a scintilla of, and they meant odor, but they spelled it order. The judge said odor. Anything with a scintilla of odor related to the Joint Commission and or CMS, indicating a classification or rating of immediate jeopardy at any time between 2015 and 2019. Anything having to do with the run up to finding or classification of ongoing immediate jeopardy as described in the CMS report January 11th of 2019. Any and all, God, they're going to have to work all weekend to get all this stuff. Any and all internal policies or procedures concerning the Joint Commission surveys, reports, findings, corrective action plans, and or compliance. Any and all immediate jeopardy templates provided to Johns Hopkins All Children's Hospital at any time between 2012 and 2019. Any and all Form CMS 2567s or any other similar documents containing official survey findings issued or documented by CMS with respect to Johns Hopkins All Children's at any time between those dates. Yeah. What, if anything? Thank you, KL. It's funny. Any and all removal plans setting forth the immediate action Johns Hopkins All Children's Hospital took or planned on taking to cure the immediate jeopardy at any time between 2012 and 2019. Any and all agreements, binding or non-binding, with CMS or any other related entity to cure the immediate jeopardy or similar deficiencies described between 2015 and 2019. Interesting. Number 21. This is the last one. Johns Hopkins All Children's Hospital internal copy of State Operations Manual Appendix Q including all archived versions. That's an interesting. I wonder what that is. I wonder what's on Appendix Q. All right. Well, that's it. We got through the motions. So now we know, now we know, you guys are saying JHACH sent the flies to my house. They're spies. They're not actually flies. They're just small drones. Now we know what the motions that the judge is going to be ruling on Monday are. So we're going to have to wait for court on Monday. And now I am going to get going because I've got stuff to do, but let me go through your chats real quick, make sure I didn't lose anything or miss anything. I did. I got a $20 Rumble rant. Brush 298 says, I'm feeling medium middle income today because payday. So appreciate your journalism on this. Maya doesn't deserve those hacks at court TV. Chronic illness pain requires immense energy to mask briefly. Yeah. And Johnny Reb 84 sent a Rumble rant, says, going to be part of the RPG, but here to be one of the medium poors. Thank you. Thank you. And I should probably check the Cash App and the Venmo too, because sometimes those come through as well. And I don't want to miss that. Okay. It looks like I'm safe. Looks like I got them all. All right. What's next? Okay, I promised locals that we would be doing a movie night or a movie together. And you guys have decided you want to watch The Verdict with Paul Newman. And I really want to watch it too. And I have laundry to do. So right after this, I'm going to take a few minutes and then I'm going to load up a locals only stream where we're going to watch The Verdict together right after this. So I don't know, like 10, 15 minutes. It's going to take me a little while to move my computer in the other room. But locals is really fun. meganfox.locals.com. We have movie nights together and we also do cooking streams over there. And it's locals only. Use promo code Maya, MAYA, and get yourself a subscription to my locals channel. And you will get a free month when you use Maya. If you use promo code SQUATS and you sign up for an entire year, you get 2 free months. So Maya is the code for monthly membership and SQUATS is the promo code for a yearly membership. So please join me over there. No, we're not watching Porky's. We're going to watch The Verdict. I've never seen it. And I was told that it's very, that I'm going to love it. And then it's going to be a lot like, it has something to do with this trial that I'll find interesting. And so I'm going to do it. I think it'll be fun. Well, watch her. Just go to meganfox.locals.com and sign up. Sign up. I think there's a one-time charge if you just want to sign up for one thing. I think it's either $15 or $20. I don't know. I don't pay attention to what it's doing. All right. Those of you on locals, did you hear me? Did you hear what I just said? Those of you in the chat. Hello. Yes. Okay. So locals, stick around because I will be back and we are going to be watching The Verdict. It's going to be a lot of fun. All right. Meanwhile, speaking of squats, I feel like that we screwed up and didn't do them yesterday and we didn't do them today. And so, yeah, we got to do squats. So I'm going to leave you with Nick Rekieta fat shaming you to get up off your ass and get your blood moving. You ready? All right, here you go. See you guys on Monday.
You impose fatness on you. You did it by going, oh, I want the butter on the popcorn. Oh, I want the butter on the ice cream. Oh, I want the butter on the sandwich. Oh, I want the butter on the salad. Stop eating butter. Can you just get up, walk 1 mile?
To squat!
Walk farther. And if you can't walk, crawl, roll, get dragged by a goddamn forklift. Whatever is wrong with you, just move. Ever. Get off the chair, get off the couch. No one is coming to service you while you sink into that furniture, while you become one with the pleather your poor ass got on that Walmart couch. Can you try not floating into sadness? Stop eating, stop drinking, start walking, start doing anything that you haven't been doing, you fat piece of shit.